Welcome to Solutions with Courtney Anderson. I am your host, Courtney Anderson. Today's show is part of our Law Lovers Lounge series, where we always have the opportunity to indulge in the fantastic love, appreciation, admiration of the law. And we also, of course, are in a lounge, so we're just engaging in sort of general educational discussion. This is, again, as a disclaimer, not a provision of direct legal services to you. I am an attorney. I am not your attorney by virtue of taking part and accessing this program. Have to make sure that those disclaimers are always included. Thank you again for joining us, because this is part 2 of a 2-part episode. And our specific episode that we are now in our concluding part 2 of is, I have been sued by my credit card company. What now? And so here we are in part 2. In part 1, we went over the fact that many people that I've worked with anecdotally or met over the years as an attorney would tell me that they were sued by their credit card company, but they actually hadn't been. And so I spent a lot of time in part 1. I strongly would ask you to listen to that if you're not really sure you've been sued. A letter is not a lawsuit. A letter from a bank, a credit card company, a credit union, a collections agency, or a lawyer, for any of the above, is not a lawsuit. It's just a letter. A lawsuit starts the moment somebody goes to the courthouse, whichever is the correct courthouse or potentially correct courthouse for your lawsuit case, and they literally file paperwork with the government. They have to pay a government fee at that point, it's a filing fee, and that's a lawsuit. When that happens, the moment paperwork's filed and the clerk electronically or in person stamps it, they give a little time and date stamp, that's the moment the lawsuit started. Before then, if somebody's telling you they're going to sue you, or they're sending a letter telling you if you don't do something they're going to sue you, they have not sued you. They just said they would. So that's really important. So it's been a lot of time talking about in part 1 all the different parts of the nuance to understanding, were you sued or was somebody just threatening to sue you? If you are sued, how, sort of a general overview, what does that mean? And I talked a lot about the basics are that somebody, often a lawyer, goes to the courthouse, which could be literally going in physical space to a courthouse, or it could be going online to the correct courthouse filing website, government website, and they have to turn in documents that have to show who they're suing, why they're suing them, and they have to pay a fee for doing that. That's what starts the lawsuit, is the filing of the paper with the government. Then I spent time in part 1 explaining that when somebody does that, they go to the government and they turn paperwork in, which starts a lawsuit. When the government accepts it, the challenge then is, how do you make sure that the person they've sued knows they've been sued? And so I spent some time in part 1 going over that, explaining that usually there's a process whereby the person who's been sued is served. They're actually given the paperwork showing that you have been sued. And it says on the paperwork, you have been sued. And in most of the jurisdictions that I've ever encountered, or all of the ones I've encountered, it's always been in really visible, where it says you have been sued. It's been in bold font. It's been big font. It's been underlined. It's been in multiple languages in case that's an issue. You have been sued. It'll tell you, it'll repeat again when you were sued, where you were sued, and then it'll start to talk about something that's really important. Once somebody sues you, I said the moment you've been sued, when they go file the paperwork with the court, right? And the court takes it and stamps it. When the court takes the paperwork, they're not saying that the paperwork is correct. They're not doing anything. All they do is take the paperwork, take the fee, and then put a stamp on it. They don't read it to tell you whether it's legally correct. They don't read it to tell you whether you have the right language or the right law. They're not doing anything. They're literally clerks. Their job is to take in the paperwork. The moment they take the paperwork in and they put the little stamp on it and they enter it into their government systems, you've been sued. Now, nobody's looked at the paperwork to see if it's true, quote-unquote, false, quote-unquote, to see if it was in the right court, the wrong court. Nobody's checked to see what the paperwork says. All they're doing is just taking it. They're just doing an intake. That's their only job at that part. They take the fee, and then they take the paperwork. So it doesn't mean anything in terms of the veracity, the truth of the underlying lawsuit. It doesn't mean at all that it was filed in the right place. It doesn't mean that it's been filed correctly according to all the different rules about filing lawsuits. But it just means that they filed it. That's all it means. So don't misunderstand that ever. Once you have been sued, they went to the court, turned the paperwork in, now you've been served. I left off at the end of part 1 saying that it used to be interesting to me that I would go to court on credit card lawsuits. So most of the time when I went to court on credit card lawsuits, I was the lawyer representing the person who lent the money to the defendant. I represented the entity representing the credit card company, if that makes sense. I represented the person or the corporate person who was the credit card lender. That's the plaintiff. Plaintiff is the legal word, the person who's suing you. They're the ones that start the lawsuit, the plaintiff. They accuse you, the defendant, of doing something illegal. In a credit card lawsuit, the plaintiff is accusing the defendant of the illegal thing being that they breached the credit card contract. They didn't pay what they were supposed to. So I represented most of the time the credit card companies, and I represented them indirectly the majority of my experience in this area. Most of the time I was what I shared called a local counsel law firm. So again, there's so many different companies that issue credit cards, and many of them are banks and credit unions. Some of them are other businesses that just have sometimes the credit card is issued by a different business than the name of the company that you dealt with. So maybe you dealt with an airline or something, and your credit card has the airline's name on it, but there's another business usually underlying that whose real business is in the credit card or lending business, the consumer financial business. It's not the airline that whose name is on there is the one that you're going to sue. It's usually a different name of a different company who's really the one that's behind the credit cards. Because businesses that are usually an airline or some other type of business that aren't in financial services, they themselves aren't going to usually go out and create a whole other internal business entity to sell credit cards. What they're usually doing is they're partnering with another business that is in the credit card business, and then there's a fee exchange so that it's a benefit for them to have their branding on the credit card. Okay. So whoever it is that says they loaned you money on the credit card will go out and have their lawyer, and then they'd sue you. I have nothing to do with that when I'm local counsel. What happened after the lawsuit is then the law firm representing the plaintiff, which is the lending institution that says that you owe them money, the credit card company, they would then contact me and say, okay, we have these credit card lawsuits. You have a credit card lawsuit in your geographic area, and we don't want to send one of our lawyers from wherever, some other part of the country or far away. We don't want to buy a plane ticket and put them on a plane and get them a rental car and a hotel and pay for food and everything to go to the court for this. We're going to hire your firm as a local law firm to go to court on this. And since the case has already been filed and everything, I didn't know about that process. I wasn't involved. By the time I was hired, the case had been filed, and now it's set to go to court for either a hearing or for trial. So I would go to court, and I shared at the end of part 1, I was always interested when I go to court, and I'm in the right court at the right time, which is always the hardest part of a lot of this, so just the logistics. And so it's a Tuesday morning at 9 a.m. I'm in this court. It's the right court for the lawsuit my client law firm hired me to come to as their local counsel representative, and they would call a lawsuit case. Lawsuit, whatever number, and they'd read a number, and then they'd read the name of the lawsuit. So the names would be the plaintiff, right? So whatever. It would be, Discover or Chase or Capital One. It would be some big financial firm, right, who is the lender. And then it would be versus the defendant, which would be usually a person, although sometimes it would be a business. And so they would call the case, and then, so that they called the case, and then it was, such and such bank versus, Steve Smith. And then Steve Smith, the person, would be in court, and they'd stand up when they called the case, and they'd say, oh, I'm here. And then so many times when I go in front of the judge to talk about those cases, the person who's in the courtroom would say something like, well, I never even knew about this lawsuit. I was never served notice. Nobody ever told me about it. They didn't always use the word served notice, but they would say, I didn't know about this. Nobody told me I was sued. Okay. And then I would always ask, well, if you didn't know you were sued and nobody ever told you about it, then how are you here? Like, we're physically here. This isn't some sort of thing where you're just randomly walking around the shopping mall and you just trip and fall and now you're in a courtroom. Like, this, we're at a place that specifically is this courtroom. So we're in some sort of building, and I've been to all different types of courtrooms all over the world, but definitely in the U.S. I mean, in the U.S. there's some that are in big buildings that are really fancy and have a lot of, different rooms in them. I've been to some courts in small rural parts of the U.S. where the court literally will be like a little portable, like a mobile type home unit. Sometimes they're in the back of another entity, so maybe in the back of like a local general feed store is a little room, and that's the courtroom. But whatever size or shape or level of grandeur it is, it's set up as the courtroom. You're there, and is it a coincidence that you're here on the same day this is your lawsuit case? I said, how do you know to come here on Tuesday at 9 o'clock? Do you just come every Tuesday to every court? You come to only this one? You randomly go to courthouses all day and just stay there? My argument simply was, if nobody told you were sued, why are you here? And it was interesting. As I said in part one, many people will come to my law office and tell me they'd been sued by the credit card company. When I'd look and I'd say, do you have any paperwork? And they would tell me, no, there's no paperwork. Then I knew they hadn't been sued. Because when they sue you, they have to give you paperwork. When somebody threatens you on a phone call that they're going to sue you, that's not a lawsuit. That's just them telling you they might do it. If somebody sues you, they're required to make sure that you're served notice of the paperwork. You're literally given the paperwork, a copy of what they've sued with, a copy of the paperwork they filed at the courthouse. You're given that, and on top of that, there's almost always additionally some sort of a notice that says you have been sued. It's trying to tell you every way it can think of, you've been sued, and here's the paperwork that was filed at the court. So if you don't have any notice of that, you don't know you've been sued. And here's the other thing. How would you know when to show up? How would you know to show up on Tuesday at 9 o'clock? None of that makes any sense if you never were given notice, because you're here. So the first part in part one, we talked about, have you really been sued? Now in part two, we're assuming you actually were sued. This wasn't a threat to sue you. It wasn't a letter. It wasn't just some random phone call. It literally is a piece of paperwork that says you have been sued. Once you get the paperwork that says you have been sued, then you have to understand that there's a whole other set of rules that kick in. Once you've been sued, then your big options are this. You can totally, absolutely do nothing. If you do nothing and you just ignore the paperwork that says you've been sued, and you just either ignore it or throw it in the trash or whatever, and you just hope it'll go away, what'll happen most of the time is this, especially with the credit card case. Most credit card lenders are larger lending institutions. Usually you don't see like a really small mom and pop, that's got 4 employees, and then they're in there in the credit card business, just because there's usually a lot of infrastructure costs in the credit card business. So you usually have bigger businesses. A bigger business is going to usually have some sort of internal process. Once they go ahead and they sue you, then they're going to show up for court. Meaning, if you throw it in the trash and it's a credit card company, that's a business, and somebody in that business went through the hassle of filing a lawsuit, so they're probably going to also not just ignore it, if that makes sense. And that means if you ignore it, then you're taking a big risk of the following happening. When somebody files a lawsuit, remember, at that point, nobody's looked at the paperwork, nobody's made any determination. All that clerks do is just intake paperwork. What it says, that's not their issue. They're not allowed to practice law or tell anybody what it means. That's what a judge is supposed to figure out, or a jury if you went to a jury trial. So they just take paperwork. Who knows if it's accurate or correct or wrong or anything? Who knows if it's even you that they're talking about? Nobody knows. Nobody's checked. So when you get the paperwork that says you have been sued, option one, you could do nothing. If you do nothing and the other party continues with the lawsuit, meaning that they move through the legal process, what they're going to do is go in front of a judge and ask for either a hearing. Sometimes you can go to court and say to a judge, look, there is really nothing that's in dispute about this credit card. Here is everything that happened. Here's a copy of the person when they applied for the credit card with their signature and their date. Here's the contract that they signed by acceptance of the credit card. Here's a copy of the statements, all the statements they had, all the bills that they paid. Here's what happened when they stopped paying. Here's the current amount of money that's due. There's nothing to dispute. So there's some legal things you can go in front of a judge and say, there's nothing to argue. We have all this evidence, and they can ask for the judge to just rule in their favor, and they can do that on a motion. So they can do a motion for summary judgment, or there's different types of things they can do where they're just saying to the judge, hey, look, there's so much evidence, nothing really disputed, just rule in our favor. Or they can just go ahead and set your credit card case for trial, which is where they're going to have to go to court and prove that it was you and you owe the credit card. But no matter if they're going to go for a hearing or for a trial, if you ignore the paperwork you got that said you've been sued and you do nothing, what's going to happen is then they're going to go to court and they're going to say, look, Your Honor, we filed paperwork and the defendant was given notice. They were served notice. And here's the receipt showing the day they were served notice and how they were served notice, what time they were served notice, et cetera, where. And every single court has rules that say if somebody sues you and you're given notice, you have a certain amount of time after you're giving notice to respond to the lawsuit. Most of the time when you respond, it's called an answer. When you respond with your answer, the answer could be, I received the lawsuit. You could generally say, hey, I received the lawsuit and I deny everything that in the pleading. I just general deny. It's what's called a general denial. I deny all of it. You can respond and answer and say, the answer is what it sounds like. It's an answer. It's an answer to this allegation. Somebody turned paperwork in and said that you did something that was illegal. You can answer that and say, I deny it. You can answer it and say, you could answer it, and I have seen people do this. And this is one of the reasons why we're doing this show. If you receive paperwork that says you have been sued by anybody, but definitely by a financial institution, a credit card, a bank, over, a car loan, just anything financial. Look, you can answer it, and just the answer can say, I deny it. You could answer it and say, I got the lawsuit and I did this. I had this credit card and I didn't pay my bill. I have seen so many people do that, and almost all of them are handwritten or they're typed by the person, so they didn't talk to a lawyer, because no lawyer is going to tell you to do this, because it's not in your own best interest. But you can, and people do it all the time. I've seen it happen. So they get sued. It says you have been sued. They don't ignore it or throw it in the trash, but they write down an answer, and the answer says, I did do this. I had this credit card, and I owe this amount of money. But there's a certain amount of days that you have to respond to the lawsuit, right? So the lawsuit's filed on a certain day. You got notice of it, 3 days later. The clock starts ticking the day you get notice. Clicking on what? Clicking on you responding. If you absolutely positively have received notice of a lawsuit and you don't respond, and the days that you were given, so like a lot of times it'll say you have to, you have till 10 a.m. on the Monday next after 20 days have expired. They're usually worded weird, but what they're trying to do is tell you, from the moment you get notice, count 20 days, and then you can, in some jurisdictions, that 20th day is the day you have to get the answer. In some jurisdictions, they'll give you to the next Monday, which is, when courts open. And, but however they'll tell you, it's all written down. It'll tell you, you have been sued, and it'll tell you have so many days to answer. What's an answer? It's what it sounds like. The lawsuit started when somebody filed with the court paperwork saying, I'm suing you, right? Do you answer it by going to that same court and filing a piece of paper saying, I'm answering? And again, you can answer and just say, I generally deny everything. You can answer and you can say, I do owe the credit card, which I'm saying as general legal advice is not recommended. But I've seen all of this. And you can ignore. All right. Option one, you ignore the paperwork. You got the lawsuit paperwork that you had been sued. It said you had been sued. You understood you had been sued. The little clock started ticking. It'll tell you how many days you have. And it differs how many days you have to answer depending on the rules of that local court. Okay, so maybe you had 10 days or 20 days or 30 days or whatever. It doesn't matter how many days. Just look and see what the paperwork says. If that clock ticks down and it runs out of time and you never answer, then what the person who sued you can go to court and say is, I am asking, okay, because the person did not answer, I'm going to ask for what's called a default judgment. A default judgment is what it sounds like, default. It's sort of, like people who go to a youth soccer game. And one team shows up, we're going to have the soccer game. It's going to be on Saturday at 8 o'clock at Sunset Park, and one team shows up at Sunset Park 8 o'clock on the right Saturday, and the other team never shows up. So by default, the team that showed up wins. You just win because the other team didn't show up. It's the same thing with this in theory, very generically. If you ignore the case, you do nothing, then the person who sued you is going to go to court and say, hey, I have proof that they were served notice. I have proof of how many days have gone by, and they have missed the clock. The clock ran out of time. They never, ever did anything. They never responded. They never answered. So I'm going to ask you, court, to give me a default judgment. You have to just give me everything I've asked for. You have to just sign off and agree to give me everything I've asked for, because the other side they were given notice that they were sued by me, and they were given time by the government, that's how many days they have to respond, and they didn't do anything. And because they didn't do anything and they had notice and they didn't respond, then you have to go ahead and by default, I win because I'm the only one that showed up. This is what happens in the overwhelming majority of these consumer finance cases. Just overwhelming. It's incredible how many people don't show up. And one of the main reasons I said I did this program is to beg you to show up. For if nothing else, here's the thing. Most credit card cases are very small amounts of money. Now, money's all relative. So if I don't have $2 and I have a bill for $2, then it doesn't matter whether it's $2 or $2 million. The same thing as I don't have it. But in general, a lot of these consumer credit card cases are relatively small numbers in general. So a couple $100, maybe a couple $1,000, right? If you do nothing, literally nothing, then most likely, unless the plaintiff, the person suing you, the company suing you, unless they decide to quit, which they can, but as long as they show up to the match, which is the court setting, and you don't, and you've never filed any paperwork, they're going to ask for a default judgment. And I'll tell you the truth, most judges, technically, the law says they have to give it to them. Now, if the person who sued you can't prove you were given notice, and I'm going to tell you the truth, many of them cannot. But if they can prove that you were given notice, you did get the notice, and you knew how many days you had, and you just ignored it and didn't do anything, or you were scared or confused or whatever, it doesn't really matter, and you're not in court, then yeah, they're going to get the default judgment. And default judgment, again, the judge isn't technically supposed to be asking them anything other than making sure that they are in the right court, that this is the kind of case that court hears, that the dollar amounts are in that court's jurisdiction limit, and then they're just supposed to sign off on whatever it is that they say you owe them, because you're not there to ever say anything. You never showed up for the match. Please don't do this. It is so preventable. Option one was you ignore it, and if you ignore it, then if they keep showing up and doing things, what do I mean? They can withdraw the case, they can dismiss the case, they can not show up themselves. All those things are possible, but they're not that likely. So if you ignore it, most likely they will show up, or somebody they've hired will show up, like a local lawyer, and just by showing up, they win. Because you didn't show up and you didn't answer, and the time limit is over, and you're still not in court that day, so they're going to give a default judgment, which is everything that the other side asked for. That's option one. Option two, you got the paperwork, said you'd been sued, and you did answer, but you went ahead and gave one of those answers where you admit everything, which is what I just said a few minutes ago. Don't do that either. And people, usually those are handwritten, sometimes they're like hand-typed, and it will say something like, yes, I had this credit card. I did charge $574. Thank you. Well, when you do that, then you already answered it. And then people want to come to court and they want to go in front of a judge and have a discussion. My argument is, Your Honor, in their own answer, they admitted that they owed this money. There is nothing to dispute. And the answer, even if you write it in your own hand or you put it on a napkin or whatever, once you turn it to the court, then it's a legal answer. That's why I'm strongly encouraging you, in fact, I'm begging you, talk to a lawyer. Or go online and access some legal information. You need a real answer, and just saying you admit the debt doesn't really make any sense. It doesn't make any sense because of this. When somebody sues you, it's their responsibility to prove it. When someone sues you, it's their responsibility to prove it. So when you stand there and you just say, okay, I did it, then now you took away their whole liability. You just agree to it. And now some people say that they want to, it makes them feel good, fine. But if that's how you feel, then why did you make them sue you? If it's amounting to money, you feel like, okay, I do owe it, then why don't you just start paying them? Which brings me to this. The third option in general is you answer it, but it's a denial, which is the best course of action, is that you answer within the time limit as early as possible. So the moment you get sued, in fact, you need to go ahead and get your general denial answer together. That's the best advice. Because then you make the other side have to come to court and prove it. And you could also win. The default works both ways. If you answer and say, I deny everything, you also have the option in your denial to file claims against the plaintiff. You could also turn around in your answer and then file complaints against them for some sort of violation of the law. It's a whole more complicated issue, but I want to mention it. So if you file a general denial and you ask for things against the other side, so they had violated laws, then and you go to court and the company, credit card company doesn't show up, then you're going to win default on what you asked for. It works both ways, right? Most people don't understand that you can have a cross complaint against the plaintiff, but that's neither here nor there. At least the general denial, which literally is like you could have like one sentence. I deny all the allegations. I deny this, period, signed by you. That's an answer to general denial. Then you need to show up for court. Now, the court settings, the court sets those. So you got the same clerk's office, usually you file the paperwork, or at least part of that division. Those are the people who are going to go ahead and determine when do you have to go to court, what day, and all that kind of stuff. They're supposed to send notice to everybody. Sometimes things fall through the crack and they don't. So once you know what your court is, you need to stay on that, make a note, call the clerk's office, and make sure you keep asking and checking, is there a court setting on this? Once they tell you there's a court setting, you need to show up. Once you've gone this far, okay, I'm assuming, of course, that actually you owe the credit card debt. Now, if you don't owe the credit card debt at all, this is not you, it's somebody else with a similar name or whatever, then absolutely you need to stay on this. But I'm assuming that you stay on this, meaning you need to file a denial. You need to file an answer immediately within that time frame. I would suggest usually a denial, because why not? Make them prove it. They sued you, right? And then you need to show up for court. You need to make sure you stay in contact with the clerk's office. They have your right address. If you move, you need to let them know. And then when it's time for court, you need to show up. So here you are, it's time for court. Maybe it wasn't you and it's somebody else with a similar name. Maybe it is you and you just don't remember it. Maybe it was you and there's some extenuating circumstance why you don't owe the money. Okay. Make the credit card company prove their case. They sued you. You didn't sue them. I want to mention this. Many people get so angry about violations of consumer protection and debt collection laws. And yes, I mean, we could do, and I'm sure I will, just hours of programs on the violations of people's rights. Some by people who are lenders themselves. There's a lot that happens within the people who buy debt. So let's say you borrow money from me. You borrow $1 from me, fine. Then, for whatever reason, I decide, you know what, I'm tired of waiting on that $1 from you. I'm going to go ahead and somebody else will buy the debt from me. They'll take the debt and say, okay, look, that other person owes you $1. I will go ahead and give you 60 cents today. And I will buy your debt from you. So I'll get the immediacy of, I get less than my $1. I get 60 cents, but I get it in my hand. I have it now. So I'm sitting around waiting for the money from you. So I sell somebody else my debt. And once I do that, they paid me something. Now the other party legally owns my debt. They bought the paper. I mean, they bought the paperwork saying that there's a debt. This is very simplified. Once they do that, they can go ahead against you and move to get the debt from you, because now they are the owner of the debt. Even though they're not the people that you owed the $1 to originally, but they bought the debt from me. Now they can go to court. A lot of people, when they would come to court on these consumer credit card cases, got hysterically angry about that. You know, they would say, hey, look, I did have money from, whatever credit card company, whatever bank, Discover, Chase, or whatever. But, this is the person that sued me today isn't even them. It's some other, other company. It's a company who bought the debt. And I'm like, yeah, they did, of course. That's totally legal. That in and of itself is not, it's not at all anything wrong with it. Maybe something's unethical with it. I'm not going to debate whether or not morally it's the right thing to do. All I'm trying to say is that's not anything of its own, in and of itself for you to try to make that as a defense. I think what people's argument, when they made that argument and they were upset about it, I think what they were trying to say is, look, I borrowed $1 from that other person. I didn't borrow $1 from these people. And I don't understand why I can't just deal with the original person. My argument is, well, you could. But look, when you buy something and you sign paperwork, okay, so getting a credit card is somebody's giving you a loan. Even though it seems easy, and a lot of times credit card companies will send you in the mail, hey, you're pre-approved. You're so great. You're pre-approved for X amount of dollars. And people think, well, that was easy. I never even asked for any money. They just gave it to me. Once I sign off paperwork or send a little email thing in, now they send me a card in the mail. Look at that. I have all this approval of all this money. There's a lot of fine print with all those credit card agreements that tells you what all the rules are. So unless it says in there that they cannot assign that debt, that's to sell it or transfer it to somebody else, then they can. And they do. You see the same thing with other parts of teams of debt, like in mortgages. You saw when the global crisis happened, especially in the U.S., a lot of people got really angry. They didn't understand. They said, look, I bought, in their mind, they're like, I went to, a certain bank, and I thought that's who I had my mortgage with, and now they sold it. Maybe they sold it several times. I don't even understand who these other people are sending me letters telling me I owe them money. Who are they? Well, they're the people who bought the debt from whoever else sold it. And you can buy it and resell it. That's just part of the system. So I'll do some other shows on assignment and try to explain that a little bit better. So my argument is you got a certain amount of time, you got to answer. I'm arguing that you should ideally give a general denial because make the plaintiff prove it. And it might not be you, as we just talked about. You're going to show up in court. If you can afford it and it's worth it, I get a lawyer. If it's not worth it and you feel like you understand what's going on, then go yourself. If it's a small enough amount of money that you feel like you can handle it. Then just explain why it's not you. Make the other side prove it. And as we get to the close of this episode, I cannot stress how important it is for you to understand that when you make them prove that it was you, you make them stand there in court and have some lawyer show a contract. Where's the contract I signed that said that I took this credit card? Show me all of my statements that showed how much money I paid. And many of the times I'm going to tell you they don't have that paperwork. That's not a secret. You saw the media coverage about that in the global economic crisis with the mortgages, right? People would go to court and the person holding the debt or saying they held the debt couldn't even come up with any paperwork showing that the people owed them money. And it's the same thing with the credit card companies and a lot of this other financial type of situation. But you'll never figure that out if you just go ahead and ignore the lawsuit because they'll get a default judgment against you and they had literally nothing to prove their case. If you admit in your answer you owe the money, you're also not finding out if they have any paperwork. And if it's not you, and here's the thing, if they go to court and they get a judgment against you, whether it's a default judgment or you admit the debt and they get a judgment against you, one, that judgment is going to stay on your credit and just ruin your credit. I've done several other programs on credit scores. Please listen to those for that information. It's a public record against you, so anybody that's doing a search on you is going to find that because it's a public record at a courthouse. You do not need that or want that in a background check for a job or anything else. What on earth would you risk this for? A judgment is a very bad outcome when you can prevent it. And you can prevent it lots of ways. And the best way to prevent it is if it gets to court, you answered on time, denied it, showed up, make them prove it, and I'm going to tell you that a lot of times they're not going to be able to do it. So thank you so much for joining me. As always, you can come to CourtneyAnderson.com. And, of course, our law firm site is litigationmitigation.com. Thank you.